Child custody can be modified under very similar occurrences. What the court is looking for is a change in circumstance, very much like they look for a change in circumstance in modifications of child support. However, cases to modify child custody are much more difficult to win. It's why it's also very important to have a good family law attorney with you initially when these cases are decided if you seek to have primary physical custody. Of course, there are always some very significant issues that could arise following a prior order. For instance, the incarceration of a parent who may have primary custody. We often find cases where somebody has a drug or alcohol problem, and certainly these are grounds to modify primary physical custody of a child that's involved. A lot of people will call up, though, and will request whether or not they could modify child custody because they're unhappy with their current visitation plan, or because they're unhappy with their ex-spouse's abuse of the visitation order that's currently in place. And the courts oftentimes will not consider this grounds for modifying primary physical custody. The better course of action in these types of events would be to start a contempt action in the county that originated your order. If your ex-spouse or the custodial parent of your child is not adhering to a parenting plan that is specifically spelled out and is the order of a court, you have grounds to start a contempt action against that spouse for failure to live up to the order that a judge has already put in place. But I caution people from trying to make those visitation discrepancies between them a true modification of custody case. Judges rarely modify custody by changing who has primary physical custody of the child without some pretty extraordinary circumstances having taken place.